In this presentation, I will be talking about confidentiality and the law as it applies to substance use treatment. This is primarily going to be focused on Title 42, Part 2 of the United States Code of Federal Regulations. Title 42, Part 2 of the United States Code of Federal Regulations, typically referred to as 42 CFR Part 2, is the section of U.S. federal law that addresses confidentiality requirements for persons seeking or attending substance use treatment. California has adopted the federal confidentiality regulations as state law, meaning that there's no conflict between state and federal laws for confidentiality. It also means that California doesn't have a section in its own code of regulations that specifically addresses confidentiality for substance use treatment programs. In fact, they have a reference in the Code of Federal Regulations stating that certified or registered alcohol and drug counselors must follow the confidentiality regulations as dictated by 42 CFR Part 2. The basic rule of 42 CFR Part 2 is that substance use treatment programs cannot disclose the identity of their clients without written permission from the client, unless it meets the requirements of one of the regulated exceptions. So there are a handful of exceptions in which a substance use treatment program can disclose the identity of their client that are specifically spelled out in the Federal Code of Regulations. But if it does not meet one of the requirements of those exceptions, then in all cases, you cannot identify a client. Now, this law assures that individuals who seek substance use treatment will be kept secret and confidential, and their identity will not be disclosed to third parties. There are no comparable federal regulations for other medical or mental health fields. 42 CFR Part 2 is uniquely strict. The question is why? Society stigmatizes individuals with drug or alcohol problems. There is ample research showing that addiction or substance use disorders is amongst the most stigmatized conditions that people can have, meaning that when someone has that condition, they are looked down upon or judged in some way by society at large. So this law is in place in a large part to protect against the stigma that may cause individuals to avoid treatment. You can think about this in a typical work setting. Telling your boss that you are applying for the Federal Medical Leave Act because you have a serious illness and you're not going to be able to work for 90 days, your boss probably will say, "Oh my gosh, I'm so sorry. I hope everything's okay." Right? No problem. But if you tell your boss, "I can't attend work for 90 days because I'm going into drug treatment," that boss may or may not stigmatize you for that. So the idea here is that the federal law is trying to keep the client protected so that they are encouraged to seek treatment when they need it. So the primary confidentiality that you are protecting for clients in substance use treatment is identifying information. So patient or client, that word is used interchangeably, it means the same thing. Patient or client identifying information is any information that would reveal that a person is receiving or has received services or even has applied or inquired about treatment services. So any information that would suggest that Maria is receiving substance use treatment or has received substance use treatment, or that Maria called and asked about substance use treatment, that would be considered client identifying information. So the purpose of the regulations include comments, stories, impressions, basically anything that also identifies the client in any way. These are considered records for the purposes of the regulations, even if they're never recorded in writing. Meaning that if a drug and alcohol counselor goes home and they tell their spouse, "Oh my gosh, I have this client named Maria Valdez, and boy, wait till I tell you what she said today in group." That's not a written disclosure. Yet, for the purposes of the law, that is considered a record, meaning that that is a violation of the confidentiality restrictions. If two drug and alcohol counselors are in a social setting and one of them says they worked for a particular substance use treatment facility and the other person's like, oh my gosh, I worked for that facility too. And they're like, oh, wow, that's so interesting. When were you there? And then the person says, hey, were you there when Robert Johnson committed suicide? And the other person says, oh, no, I wasn't there yet, but I heard about that. That just broke federal law, because that identifying information, even though it was said casually as a type of story or comment, it's considered a record. Even disclosing the presence of a client at a facility that is identified as a place where only drug and alcohol services are provided is illegal. So a good example of this is your client, Sue, is at a treatment facility and somebody calls your treatment facility and the receptionist picks up the phone and they say, hi, can I talk to Sue? And the receptionist says, oh, I'm sorry, Sue's in group right now. That is a violation of identifying information, because if your facility is known as substance use treatment and you have disclosed the fact that the client's there, then essentially you have violated federal law. So the bottom line is that you may not ever directly or indirectly confirm or deny that a person is receiving or has received services at your treatment center without the client's consent. Again, except with some specific exceptions that we will cover here shortly. All right, handling direct and indirect inquiries when working in the field. So for all direct inquiries, if somebody is asking, can you tell me if Sue is at your treatment facility? The standard answer is, I can neither confirm or deny that the person is here or has received services at our agency. So for a direct inquiry, that's the basic response always. I'm sorry, I can neither confirm nor deny that I know who that person is or that they are here at our agency. Indirect disclosures, things you need to be really careful about, are things like program stationery that has a logo or any other identifying information. So for example, at one point, a substance use treatment that I was working at, we're talking about getting t-shirts that identified the organization. Oh, that'd be so cool if we had all these t-shirts and everybody identified themselves as the organization. One of the things that came up in discussion is, well, wait, what if I'm wearing the t-shirt as a drug and alcohol counselor and I'm standing down the street a block away from the treatment facility, but then I'm talking to a client while wearing that t-shirt? Would that be a violation of 42 CFR Part 2? And that led to a very interesting discussion about that would we be potentially identifying the client? And ultimately the decision was, yes, we need to be careful about this because this may fall under the federal indirect disclosures. So indirect disclosures are anything that indirectly identifies the client with a substance use treatment facility are to be avoided. Indirect disclosures also include things like identifying information that's not using a name. Here in Southern California, there are a lot of celebrities, media celebrities, television, movie celebrities. So telling war stories about a 7'4" former NBA basketball player in your treatment facility, that would be an indirect disclosure, but against federal law. Right, the law applies to virtually everyone. So you may not make client identifying disclosures just because they're needed in a court proceeding, whether criminal or civil, without a client's written consent or a proper court order, which I'll discuss shortly. You cannot disclose to anyone. You cannot disclose to family members, to friends, to the client's lawyer. So if a client's lawyer calls your treatment facility and says, hi, I need Sue's records because I'm her lawyer and she's in the midst of a custody battle, the correct response is, I'm sorry, I can neither confirm nor deny that anybody by that name is at our treatment facility. If the district attorney contacts you, you may not disclose information without a written consent or a proper court order. If the police show up, even if they have a search or an arrest warrant or a subpoena, you cannot disclose any identifying information unless the client has written a consent or there is a proper court order in place. Now, this applies to everyone that works at a substance use treatment program. So clinical staff, so certified and registered drug and alcohol counselors, licensed mental health clinicians, psychiatrists, it applies to them, but it also applies to residential staff members. It applies to administrative staff members. So the person who's responsible for the finances in the organization, if somebody calls and let's say there's a 19-year-old client in your treatment facility and someone calls the administrative staff member and says, hi, I'm Juan's mother. I want to make sure that Juan has, some money, so I'd like to get him a gift card. Can you give me the mailing address? Then the response is, I'm sorry, I can neither confirm nor deny that anyone by that name is here at that treatment facility. So anyone, paid or unpaid, so even if somebody's an intern or volunteering, 42 CFR Part 2 applies to them. And for the purposes of the law, a substance use treatment program is any person or agency that specializes in one or more of the following activities: substance use diagnosis, substance use treatment, referral for treatment, or prevention of a drug and alcohol abuse problem. So if the agency has any of that as part of its services, then 42 CFR Part 2 applies. What if they already know? So the law applies even if the person seeking the information already has it or had other ways to obtain it. So again, the examples I used earlier, a mother calls and says, oh, my son or daughter's there, I need to get them a message. And my response to that is, I'm sorry, I can neither confirm nor deny that anybody under that name is here. What do you mean? I know they're there. It's my daughter. I just talked to her earlier. Can you please go get her? So you cannot share that information even if they already know it. The client's lawyer calls and says the same thing. Oh, for gosh sakes, I need to talk to my client right now. I'm sorry, I can neither confirm nor deny. Now, the important thing here to note is that clients can share anything that they want with whomever they want. So the client can walk outside your substance use treatment facility, stand right on like the front porch or the front door, throw their hands up in the air and shout or jump up and down saying, I'm a client here, I'm in drug treatment. There's no problem with that. It's you as the employee or certified alcohol and drug counselor that cannot disclose any information about the client. All right, violations. So violations of the federal confidentiality laws are illegal, meaning you are breaking the law if you disclose information without a written consent. So a drug and alcohol counselor may be fined between $500 and $5,000 for each violation. Depending upon the nature of that, you may be legally liable in a lawsuit. For example, if a client is in your treatment program and they're in a domestic violence relationship and their spouse, calls and says, hey, can I speak to so-and-so? And you say, sorry, they're in group. You just identified they're there. And if that person was later attacked by their spouse and sued you and the organization for disclosing the fact that they were there, you are definitely liable. So in addition to the $500 or $5,000 violations that the federal government may hit you with, you may be standing in court for other types of damage. You also may be investigated by the California Department of Healthcare Services or one of the California certifying organizations. So violations illegal comes with numerous penalties. Now, federal regulations require that all clients are informed of their confidentiality rights under 42 CFR Part 2 with a written informed consent notice. They should receive this at the time of admission into the program and sign it with a copy kept by the administrative staff. So in other words, the law requires that you tell the clients, I cannot disclose any information about you without a written consent, except in some exceptions. They need to be fully informed about what their confidentiality rights are. And federal law states then that they should sign acknowledgement that they have been informed about their confidentiality rights with a copy kept on file. All right, so let's talk about exceptions to confidentiality, or times when you actually can say something about your clients to someone else. Now, with exceptions to confidentiality, it's important before we talk about the individual exceptions to confidentiality to note that an exception to confidentiality means that information can be released without a client's written consent. But it is very important to note that when there is an exception to confidentiality, that does not require a disclosure. So disclosure may occur if an exception exists, but it does not require a disclosure, except in very special cases, particularly if there is a special court order that's issued by a judge or it falls into one of the mandated reporting requirements. So just because you can release information doesn't mean that you must release information. And the standard for disclosing information or request for information is only to reveal the type and quantity of information that's necessary to answer the specific query. So limit what you share, and it should be limited to just specifically what it is that an individual person is asking for. 42 CFR Part 2 confidentiality regulations also apply to mandated or court-ordered clients, unless disclosure is an official condition of the judicial proceedings. So what that means is, unless the client comes in the door with an already signed consent that says, as part of me being here, I need you to communicate with my parole or probation officer and or the judge of the court, then the same confidentiality restrictions apply. Now, typically with a court-ordered or a mandated client, they're almost always going to have signed a consent to release information to the court as a requisite for treatment. But if that were not in place, then again, the confidentiality restrictions apply to those clients too. All right, so the first exception to confidentiality, and the primary one, 90% of the time, this is when you're going to be disclosing information. It's when the client has signed a written consent. So if the client wrote a consent that says you may release all treatment information to my lawyer, including my intake assessment, my group and individual counseling notes, my discharge plan, and all of my psychiatric records. So if they write all that down and they sign it, now you may disclose the information. Now, the release itself, which will not be covered in this lecture, needs to meet all the requirements of 42 CFR Part 2. Suffice it to say that a written release of information for substance use treatment is more strict than a standard medical release. Now, once again, a written consent means that you may release information without liability, but even if you have a written consent, you may elect not to make the requested disclosure. Again, remember that a client can always disclose anything that he or she wants to disclose. But you may choose not to disclose that information, even if the client signed a written consent, and you will not be penalized or held liable in any way. An example of this may be that a client comes into a treatment program and they are in an abusive and controlling relationship with a girlfriend. And you know this clinically, and then one day they come to you and they say, hey, my girlfriend wants to know how I'm doing in treatment. I signed a release, can you talk to her? And clinically, that feels like the wrong decision to make. There's really no information you should be sharing, with this girlfriend. So in that case, even though your client has signed a consent and the girlfriend contacts you and says, hey, I know my boyfriend signed a release, I need to know what he's been talking about in treatment, you can elect not to say anything, and that's fine. Again, client can disclose anything that they want. Now, it's important to note that even when a written consent is in place, you must notify the recipient of that information that the information is confidential and is bound by the 42 CFR Part 2 regulations. And very important, a person who receives confidential information, even if there is a written consent in place, cannot redisclose that information to anybody else without proper written authorization. So meaning that if a client signs a release of information for you to disclose information to their lawyer, and then their lawyer discloses that information to another lawyer, right, or another person, then that's illegal because that is a redisclosure without a written consent. In addition to documenting the consent, all disclosures to third parties must be noted in the client's treatment file. So if a client signs a release for you to speak to their lawyer and you do speak with their lawyer, you are required by law to have documented that you spoke with the lawyer and what you consented or what you disclosed to the lawyer. In California, you must get a minor's written consent before releasing any client identifying information also, even to a parent or to a guardian. Sometimes this creates tricky situations, especially if the parent is providing financial support, but they have that right. So if a 17-year-old says, you may not tell my mother anything about what I'm sharing in group, then you may not tell the mother anything that the client's sharing in group. There will always be some kind of an agreement, at least in place for billing purposes, or if the client's under his or her mother's insurance, then the insurance company and financial details, there'll be some agreement in place to talk about that, but without a written consent, and especially if the client specifically says you cannot share this with my parent, then you cannot share that with the parent. And note again that even with a consent, no information may be used in a criminal investigation or a prosecution of a client without a special court order. So even if a client signed a consent to speak to the district attorney, you may not disclose information in a criminal investigation or a prosecution without a special court order. All consents must be written. There's no verbal consents. And if a properly completed consent to release information has an organization listed, meaning if it says that Keith Burke Substance Use Treatment Facility may disclose this information to the Mark Woods Substance Use Treatment Facility, then the organizations may designate a specific person, an administrative person, to send or receive those records to the person who requested them. This gets kind of helps get around if a client says you may release information to a particular person at an organization, and then that person is on vacation for 2 weeks or something like that, versus you may release this information to my lawyer and anyone else on the legal team at XYZ legal facility. Then the organization has the right to designate the person to send and receive the records. All right. Client consents must include all these things: date, expiration date, client name, program name, name of recipient, the purpose of the disclosure, why you're disclosing that information, the specific nature of the information that's being disclosed. This should be specific. Are they asking for notes, assessments, forms, etc.? A revocation statement that says that the client can rescind or take back permission at any time. That example that I just gave of somebody rescinding a consent for you to talk to their parents. And a redisclosure prohibition notice, letting the person know that you cannot disclose this to a third party without additional client consent. Now, in this introductory lecture, I'm not talking about the details about the consent forms. Those are things that a substance use treatment facility should have in place. Those are administrative requirements. And for the most part, a drug and alcohol counselor is simply going to use the form that the agency has on file, which hopefully has been vetted by the correct people to make sure that it meets all of the federal confidentiality requirements. All right, the second exception to confidentiality is internal staff communications. What that means is that staff within a program can share information with each other about the client in order to perform their job functions. So for example, if a client shares some new, really significant information in a group counseling setting with somebody who is not their designated one-on-one counselor, that person can go to the counselor and say, hey, your client today shared something in group that was really important about a previous trauma that they haven't, talked about. I thought you should know this. That is not a confidentiality violation. So basically, once a client is inside of a substance use treatment facility or organization, people inside the organization can share information about that client in order to perform their job functions. Now, this is need to know information for the purposes of the job. That doesn't mean that people inside an organization should be gossiping about a client. And it also includes sharing information with employees who provide administrative services and the residential staff, especially in inpatient treatment facilities. So if a client is in a very depressed state and the counselor is worried about the client and communicates with the residential staff member or the house manager in the treatment facility that works the overnight shift and says, hey, can you keep an eye on my client? That's fine. That's internal staff communication. All right, the third exception to confidentiality is a qualified service organization assistance program. This basically means that if there are outside services that are being provided as part of treatment, such as funding organizations. So if the client's treatment is being funded by insurance, either a private health insurance or a public health insurance like Drug Medi-Cal in California, that outside service you can share information with. If there is childcare that's being provided through the substance use treatment facility in order for somebody to attend group, or there's some kind of healthcare services, the client has a medical condition while they are in drug treatment, that requires them to be driven to the medical appointments, or if the client is working with a vocational training program as part of their treatment goals, or if the treatment facility itself has lawyers or accountants that are working for them. So basically, any outside services that are being provided to the client as part of their treatment, those people in those organizations you can share information with. However, it requires either that the patient or client signs a consent to communicate with those organizations, or what typically happens most of the time is that the organization or person must sign a QSOA agreement authorization, which essentially says that they agree to maintain confidentiality as required by the federal regulations. The fourth exception to confidentiality is medical emergencies. So if a client is having a medical emergency, especially if a client were having a medical emergency inside the treatment facility, so they are in the middle of group and they suddenly look distressed and they grab their chest and they say, oh my God, I think I'm having a heart attack. And you need to call the ambulance, right? Well, the ambulance is driving up to the substance use treatment facility. They're coming in the door, they're picking up the client there. So in this case, this is identifying information, but this is a medical emergency. So you do not need to stop the client who is having chest pain and say, please sign a release for the ambulance. The ambulance can come in and you can disclose information. Now, the disclosure needs to be to medical personnel only. So the ambulance, so the EMTs that are working, with the ambulance, you can disclose information to them. You cannot disclose information to anybody else, like family members, et cetera. Treatment facilities can resolve this by having a consent on file to contact family members in an emergency, or the medical personnel themselves can notify the family. All right, the mandated reporting. These are really important topics and are actually covered in different lectures or supplemental lectures in our law and ethics class at the San Diego City College Alcohol and Other Drug Studies program. But it is listed in the federal confidentiality regulations. So the fifth exception to confidentiality is in a mandated reporting situation. So if there is information that suggests to you that there is potential child abuse or harm to children that might be happening, or an elder or dependent adult may be potentially being harmed, or if the client themselves is expressing intent to hurt themselves or hurt another person, then that information can be relayed to a third party. So in the case of child abuse, contacting child welfare services, elder or adult abuse, contacting adult protective services. If somebody is potentially going to harm themselves or somebody else, communicating with the police or the PERT team. These are all things that you can do under this limited exception to confidentiality. Now, only the information pertaining to the suspected abuse or harm should be communicated. No other cooperation with further investigation should be done without a court order or with some kind of client consent. So in other words, if Child Welfare Services opens up an investigation and after you call them and then they contact you and they say, hey, I need to talk to you, I need a lot more information about this client, how long they've been in treatment and their prognosis and all the rest of that, you cannot give that information unless you have a written consent. So once you broke confidentiality simply to report the suspected child abuse, then your mandated reporting exception closes. All right, the sixth one, which is an interesting one. So the sixth exception to confidentiality is crimes committed on the program premises or committed against staff members. So if a client commits a crime on the program premises, so the client steals somebody else's purse, or the client does damage, breaks a window by throwing a chair through it, right, or something like that, then that actually could be reported. Or if there's a crime against a staff member, a client assaults a staff member. Doesn't happen very often, but if a client were really agitated and attacked a staff member while in treatment, then those crimes can be reported and you can break client confidentiality. But very important, this authorization does not extend to an admission of past crimes, even crimes that are unsolved or previously unreported. So if the client discloses to you that while they were in the middle of their addiction, they robbed a bank or murdered somebody and got away with it, you cannot disclose that information to law enforcement without a client's written consent. The only crimes that can be reported are those committed on the program premises or against other staff members. Now, note, if a crime is committed on the program premises, you cannot include information or names of other clients who may have witnessed the crime or been victims of it. The client themselves may consent or self-disclose. So if a client steals another client's purse, you can report that client who stole the purse to law enforcement, but you cannot report the name of the person whose purse was stolen unless that person gives you authorization to speak to the police. Now, again, the client can self-disclose themselves. So if they want to talk to the police about the fact that their purse was stolen, they are more than welcome to do so. The seventh exception to confidentiality is approved research, auditing, or program evaluation. Typically what happens here is if a state has licensed a program or has certified a program, the state or a designated accrediting agency may come on to the site to do an audit. They may ask for client files, look at treatment plans, things like that. This is an approved auditing exception to confidentiality, where an auditor can look into a client file. Sometimes a program may be evaluated, in some other capacity. The program has decided to apply for accreditation with CARF, which is a certifying organization for licensed residential treatment programs in California. And, CARF is going to do an evaluation of the program. In that case, then information can be released without client consent. However, the auditors themselves or the evaluators must sign a written document that restricts basically how they can use that information. And that written document will be handled by your program administrators, but it essentially says that the researchers, auditors, or evaluators are bound by the same federal confidentiality restrictions as the clinical staff. And they may not redisclose any of that information. Certain infectious diseases can also be an instance where you can break client confidentiality if required by state law. Now, in the state of California, so that was what the federal law says. If the state law requires you to report certain communicable or infectious diseases to the public health authorities, then you may do so. But in California, a certified drug and alcohol counselor may disclose communicable infectious diseases to public health authorities, but they are not required to do so. So if a client comes into the program, and they have tuberculosis, A drug and alcohol counselor may contact public health authorities to alert them to the fact that there's a case of tuberculosis, but they are not required to do so. Now, this question always comes up, so we'll call it a little bonus round here. What are the legal requirements to report HIV if a client is having unprotected sex with a partner? So in the case of HIV and unprotected sex, at least in the state of California, there is a relevant law. So the California Health and Safety Code 121015 addresses reporting HIV, and it applies to physicians only, so only to medical doctors. So for the medical doctors, before they disclose this information to a partner, they must educate the patient, try to get consent, tell them, hey, I'm going to inform your partner that you're HIV positive and having unprotected sex. Let's have you do it instead. But clinicians, so mental health clinicians and drug and alcohol counselors have no mandated duty to inform partners. However, a drug and alcohol counselor may choose to break client confidentiality, and they are excused from liability so long as they contact the local public health department. So if as a drug and alcohol counselor, you know that your client has HIV and they are having unprotected sex with some new partner that they've been dating for the last 3 months, and you're really concerned about this, you're having a major ethical quandary, you can contact the local health department and inform them that you're aware of the situation. Now, if a client states that he or she intends to harm another person by deliberately infecting them with HIV, then that may fall under the Tarasoff regulations, or the regulations regarding intent to harm another person. That will not be discussed in this lecture on the federal confidentiality laws. But in that case, you may be under mandated reporting exceptions. All right, then special court orders. So the special court orders that have been mentioned a couple of times are not search warrants, arrest warrants, or subpoenas. So it will happen, it has happened to me many times in my career where I've been subpoenaed or received a subpoena stating that I need to give over certain information about a client. A subpoena is not a special court order. Police have been known to show up at treatment facilities with an arrest warrant saying, I know that this person is here inside this facility. I have an arrest warrant. You need to let me into the premises. That is also not a special court order. So a search warrant, an arrest warrant, or a subpoena does not meet the requirements to release confidential information. So in those cases, by federal law, you cannot release identifying information. Now, the program and client whose records are being sought by a special court order must first receive notice that someone applied for that special court order. So in other words, if a district attorney is issuing an arrest warrant, and they know that the person, they have information the person's there in your treatment facility, they can go to the court to get a special court order. However, the substance use treatment program and the client themselves will receive notice first that somebody is applying for a court order. So if a court order shows up at your treatment facility and you did not receive previous notice that it was coming, then that does not meet the federal regulations. So the program and or the client must have an opportunity to make a response to the court order request. So the district attorney goes to the judge, says, hey, I need a special court order. This guy, Keith Burke, is in a substance use treatment program. I'm investigating him for, I don't know, some horrific crime. I need you to sign this order, so that I can go arrest him. So in that case, the judge needs to let the treatment program know, let me know that that's happening. And before the judge issues the court order, there must be an opportunity to make a response to the request. So you don't have to oppose the request, but you have the right to do so. So let's say that I murdered somebody and now the district attorney knows it. And my counselor did not reveal that information to law enforcement because she's a very good counselor. But in this case, she feels like I have no remorse about the murder. It's actually, I'm only in treatment because I'm trying to, I'm hiding out from the cops. I'm trying to avoid arrest. she doesn't have to oppose the court order. She could if she wanted to, but the provider, the substance use treatment provider, or the drug and alcohol counselor does not need to oppose the request. And the application for a court order must use a fictitious name until the court order is granted. This is not going to happen very often. As alcohol and drug counselors, you are way more often going to be presented with subpoenas and search warrants than an actual special court order. There are multiple steps that an individual has to go through in order to get one of these things, and it doesn't happen very often. Just know, though, that there are a whole bunch of hoops that they need to jump through, and all those boxes need to be checked off before the court order is valid. Now, any proceedings regarding special court orders must be confidential. In other words, not open to the public, because obviously if they were open to the public, the risk is potentially disclosing identifying information. So hearings for special court orders are typically held in judges' chambers or a closed courtroom. And the court can only issue that special court order if it can make a determination that there is good cause for the disclosure. So the judge must rule that there is no other effective way to get the information, and the public's need for the information outweighs the client's right to privacy. All right, so there is an exception to the rule when the government is conducting a criminal investigation. So if the Department of Homeland Security is investigating a potential terrorist event. In that case, then notice is not required to be given to the patient or the client. In that case, only the substance use treatment program needs to receive notice about the hearing. Now, a program may apply for a court order itself if it wishes to disclose protected information. So let's say that, I'll go back to the example I was using before. I committed murder, and I'm not remorseful about it, and it was really horrific. And my counselor is really concerned about the ethical quandary of knowing this happened. And she goes to her program manager and says, I'm really worried about this. He's not even really participating in his treatment. He's just hiding out in here because he doesn't want to get arrested. And the program manager says, at this point, based on what we're talking about, I think that, we need to say something about this. The program has the legal right to apply for a court order themselves if they want to disclose that protected information. Now, let's talk about subpoenas for just a second. So drug and alcohol counselors will get served with subpoenas. It is definitely something that happens out there in the field. Most of the time, the lawyers that are issuing subpoenas are not familiar with the federal code of regulations regarding confidentiality. So when you receive a subpoena, you don't want to ignore the subpoena. That'll get you in trouble. So what you need to do is contact the person issuing the subpoena and explain to them that the federal regulations prevent you from complying unless they get a special court order that meets the 42 CFR Part 2 regulations. And you want to then follow it up in writing. So either email them, right, or send them a letter if you spoke to them on the phone that says the same thing. Now, your organization should have things in place in order to handle this. So for the most part, if you get issued a subpoena, go talk to your program manager or your director, and hopefully they have what's needed in order to respond to this. Otherwise, there's a lot of information online about how to reply to a subpoena in the case of 42 CFR Part 2 restrictions. So I have personally done this a number of times in my career, and sometimes I hear nothing from them ever again. I recently had one, though, where then, they followed up with a subpoena that, had a judge's signature, and they said, okay, there's the court order. And I told them, I'm sorry, that's not the special court order that meets the 42 CFR regulation. I'm still refusing to give you that information. Now, if they simply say, well, too bad, I've issued you the subpoena, I'm a lawyer, you're not, and if you don't show up at court, we're going to arrest you, then you should go to court. I mean, in that case, you don't want to ignore this stuff because it can cause you all kinds of problems, or if you somehow end up with a judge that isn't familiar with the federal code of regulations, I mean, you certainly don't want to be spending time in jail while your lawyer works all this stuff out. So I haven't ever had this happen, but the recommendation would be that, if in fact the lawyer insists that you must present this information, Then you need to go to the court on the day of the designated in the subpoena, and then you just need to explain it to the judge. It's a good recommendation to bring a copy of the Code of Federal Regulations with you. Well, this has not personally happened to me. It's happened to 2 drug and alcohol counselors that I've worked with in the past, where they actually went to court and on the day of the subpoena, and they simply handed over a copy of the 42 CFR regulations to the judge and explained to the judge why they couldn't release that information. And in both cases, the judge said, "You're absolutely right. So sorry to inconvenience you for coming to the court. See you later." So that's the best way to handle that. All right. And then the final exception to disclosure is if you're not using client identifying information. So in limited circumstances, a disclosure can be made if it doesn't reveal any patient identifying information. In other words, it doesn't identify that the client is receiving services or is residing at a drug and alcohol facility. So the example of this is, let's say your client shows up, you're in an outpatient treatment program, client shows up to group drunk. They're just rip roaring loaded, stumbling around, slurring their speech. You say to them, "I'm sorry, you are not in a condition to participate in group today. I'm going to ask you to leave." And they say, "Fine." And they reach in their pocket and they bring out their car keys and they go stumbling off to their car. So in that case, you can call the police and report this, so long as you do not identify yourself as an employee of a substance use treatment facility or having witnessed this at a treatment facility. So in other words, if you call and say, "Hey, I'm reporting there is a person in a green Honda Civic, license plate number, yada, yada. This person appears to be intoxicated. I just saw them drive down 17th Street, heading towards Main Street." That's fine. So long as you don't say, "I'm Keith Burke. I'm calling from XYZ treatment facility. I was running group today. The client showed up intoxicated and I asked him to leave." That would be illegal. What about HIPAA? So HIPAA is the federal regulations, confidentiality regulations regarding insurance and medical records. In almost all cases for substance use treatment programs, 42 CFR Part 2 is more strict than HIPAA. So you would always follow the strictest law or the regulations. Many HIPAA provisions permit disclosures, but they don't mandate them. Whereas 42 CFR prohibits disclosure, specifically talks about you cannot disclose in any instance unless the specific exceptions to confidentiality are followed. So it tends to be more restrictive. All right, so the bottom line then for the federal confidentiality regulations is simply keep it in the house. Zip your lips, keep it confidential. Don't talk about your clients unless you have some form of a written consent.